The champagne glass felt fragile in my grip as I listened to Patricia Harper announce to her 60 closest friends that her son had married beneath him. Poor David, she sighed dramatically, gesturing toward where I stood by the appetizer table. 3 years married to someone who can't even hold down a steady job. I keep telling him he deserves better. The murmur of agreement from her guests should have stung, but instead, I found myself fighting back the smallest smile. Tomorrow morning, I would be presiding over one of the biggest custody cases in Travis County, but tonight, I was apparently Austin's most accomplished failure. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. My name is Natalie Harper. I'm 32 years old, and for the past year I've been serving as a district court judge in Austin, Texas. This is the story of how one birthday party changed everything between my mother-in-law and me forever. The evening had started like every other social gathering at Patricia's Westlake Hills mansion. Elegant floral arrangements dominated every surface. Catered hors d'oeuvres circulated on silver platters. The guest list read like a who's who of Austin's legal and business community. Patricia had spared no expense for her 60th birthday celebration, and she made sure everyone knew it. I had arrived 30 minutes earlier with David, my husband of 3 years, wearing a navy dress that I'd carefully selected to strike the right balance between professional and understated. David worked in marketing for a prominent advertising firm downtown, and while his career was solid and respectable, it was clear that in Patricia's eyes, her son had settled for mediocrity when he chose me. The first comment came while David was fetching drinks from the bar. Miss Whitman, one of Patricia's longtime friends from the country club, approached with what she probably considered a sympathetic expression. "Natalie, dear, are you still between positions?" she asked, her voice carrying just loud enough for nearby guests to overhear. "Patricia mentioned you've been having such a difficult time finding work." I nodded politely, taking a small bite of the salmon canapé I'd been holding. "I've been keeping busy," I replied simply. It wasn't technically a lie. The caseload in family court had been particularly demanding lately, with several high-profile divorce proceedings requiring extensive preparation and research. Mrs. Whitman's friend Diane joined the conversation, her expression dripping with practiced concern. "It must be so hard, especially with your background. Patricia told us you went to law school but couldn't make it as an attorney. All that education going to waste." She shook her head sadly, as if mourning a great tragedy. The truth was more complicated than they could possibly imagine. I had indeed graduated from the University of Texas School of Law, finishing in the top 10% of my class. I'd spent 5 years working as a family law attorney, building a reputation for fairness and thorough preparation that caught the attention of the Judicial Nominating Committee. When Judge Harrison announced his retirement, I was one of 3 candidates considered for the position. The appointment had been a dream come true, representing everything I'd worked toward since my first day in law school. But Patricia didn't know any of this. In fact, Patricia knew very little about my professional life beyond what David had told her during our early courtship, when I was still working long hours as an associate attorney, often missing family dinners and social events. Back then, she'd complained that I was too focused on work, that I didn't prioritize family time. Now she complained that I didn't work enough. The irony wasn't lost on me as I listened to her hold court near the fireplace, regaling her guests with tales of my professional inadequacy. "She's always been flighty," Patricia was saying to a small circle of attentive listeners. "Never could stick with anything. David's been carrying the financial burden of their marriage practically since day one." Robert Chen, a prominent real estate developer who'd been one of Patricia's clients for years, nodded thoughtfully. "These young women today don't understand commitment," he said. "They want everything handed to them without putting in the real work." His wife Linda chimed in with apparent authority. "My daughter-in-law is the same way, always has some excuse for why she can't contribute meaningfully to the family." The group murmured their agreement, united in their shared disappointment with the younger generation's work ethic. David returned with our drinks just as Patricia launched into what I recognized as one of her favorite stories about my supposed shortcomings. "Last Christmas, I asked Natalie what she wanted to do with her career, and she couldn't even give me a straight answer. She had just vague talk about helping people and making a difference. No concrete plans, no ambition. It's heartbreaking, really." I remembered that conversation differently. Patricia had cornered me during Christmas dinner, demanding to know when I planned to give her grandchildren and suggesting that my little job wasn't important enough to delay starting a family. I'd tried to explain that my work required significant time and emotional investment, but she dismissed my comments as excuses. "Mom," David said quietly, appearing at my elbow with a gin and tonic, Maybe we could talk about something else tonight. Patricia waved his concern away with a perfectly manicured hand. Oh, sweetheart. I'm not criticizing, I'm just worried about both of you. Marriage is a partnership, and partnerships require both people to contribute equally. She looked directly at me as she spoke, her meaning unmistakable. The conversation continued around us as more guests joined the circle, each adding their own observations about career ambition and marital responsibility. I sipped my drink and listened, cataloging every comment and filing them away for future reference. Carol Thompson, a family friend who'd known David since childhood, suggested that perhaps I wasn't cut out for the professional world, and should consider focusing on domestic responsibilities instead. Some women are just better suited for supporting their husbands' careers, she said with the confidence of someone who'd never worked outside the home. There's no shame in admitting that. Margaret Foster, Patricia's bridge partner, nodded emphatically. My grandmother always said that a smart woman knows her strengths. Not everyone is meant to be a career woman. The evening progressed with more of the same. During dinner, served in Patricia's formal dining room with her grandmother's china and crystal glasses that caught the light from the antique chandelier, the conversation turned to local politics and recent changes in the court system. Several guests mentioned their frustration with what they perceived as increasingly liberal judges who didn't understand the importance of traditional family values. Judge Harrison was a good man, declared William Foster, Margaret's husband and a longtime member of the Austin Bar Association. His replacement is probably one of these young activists who thinks being a judge is about making social statements instead of upholding the law. Patricia nodded vigorously. That's exactly the problem. These appointments are political now, not based on merit. I'm sure whoever they picked doesn't have half the experience Judge Harrison had. I took another sip of wine and remained silent, watching David shift uncomfortably in his seat beside me. He knew the truth about my appointment, of course, and had been proud and supportive throughout the confirmation process. But he also understood his mother's personality well enough to know that revealing the truth prematurely would create an entirely different kind of scene. The whole judicial system needs reform, continued Mr. Foster. Too many unqualified people getting appointed to positions they haven't earned. Mrs. Whitman leaned forward conspiratorially. I heard the new family court judge is some woman who barely practiced law for 5 years. Can you imagine? Deciding the fate of families with so little experience. The table murmured their disapproval, united in their certainty that the judicial system was declining due to poor appointments and political consideration. I found myself wondering what they would say if they knew that the unqualified woman they were disparaging was sitting right there, cutting her braised short rib and listening to their every word. Patricia stood to make a toast as dessert was being served, her champagne glass catching the warm light as she addressed her guests. Thank you all for being here tonight to celebrate with me, she began. At 60, I've learned that life is about surrounding yourself with quality people who share your values and understand what really matters. She paused, her gaze sweeping the room before landing on David and me. Family is everything, but family isn't just about blood relations. It's about the people who contribute positively to your life, who work hard and take responsibility for their choices. The emphasis on work hard wasn't subtle, and several guests glanced in my direction. Some people understand this instinctively, Patricia continued, while others need more guidance to find their way. I'm grateful for friends who support each other through life's challenges, even when those challenges involve family members who haven't quite figured out their place in the world yet. The applause that followed felt hollow, and I noticed several sympathetic looks directed toward David, as if his guests felt sorry for the burden he carried in being married to someone so directionless. Miss Chun reached over to pat his shoulder consolingly, while her husband shook his head with what appeared to be genuine sadness for my husband's situation. After dinner, as guests mingled in the living room with coffee and brandy, Patricia pulled me aside into her study, closing the door behind us. The room was decorated in rich burgundy and gold, with legal books lining the shelves and framed photographs of Patricia with various Austin dignitaries covering the desk and side tables. Natalie, she began, settling into the leather chair behind her massive mahogany desk. I think it's time we had an honest conversation about your future. I remained standing, my hands clasped in front of me, waiting to hear what wisdom she felt compelled to share. You're a lovely girl, she continued, but you're not getting any younger, and this pattern of job instability is becoming a real concern for David's future. He needs a partner who can contribute financially and socially to their marriage. She gestured to the photographs on her desk, most of which showed her with successful Austin businessmen and their wives at various charity events and social gatherings. These women understand what it means to be a professional wife. They support their husbands' careers while building their own reputations in the community. Patricia leaned forward, her expression becoming more serious. I've been thinking about this for months, and I have a proposition for you. My friend Helen runs a very successful interior design firm, and she's looking for an assistant. It's not glamorous work, but it would give you some structure and a steady paycheck while you figure out what you really want to do with your life. The offer was clearly meant as a kindness, though it came wrapped in layers of condescension that were impossible to ignore. Patricia genuinely believed she was helping me by arranging a job that would keep me busy while not threatening anyone's perception of traditional gender roles. I appreciate the thought, I replied carefully, but I'm quite satisfied with my current situation. Patricia's eyebrows rose slightly. Your current situation being unemployment. My current situation being my career, I said simply. She sighed, the sound conveying years of accumulated frustration with what she perceived as my stubborn refusal to accept reality. Natalie, I don't know what David has told you, but pretending you have a career when you clearly don't, isn't helping anyone. It's time to be practical about your limitations and make choices that benefit your marriage. Through the study window, I could see the lights of downtown Austin twinkling in the distance, including the building where I spent my days presiding over cases that affected real families facing genuine crises. Tomorrow, I would be back in that courtroom.
Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story.
Making decisions that required the very experience and judgment that Patricia was convinced I lacked. I understand your concern, I said finally, but I think you might be surprised by how things develop. Patricia smiled indulgently, the same expression she might use with a child who insisted they could fly if they flapped their arms hard enough. Oh, sweetheart, I admire your optimism, I really do, but optimism without action is just wishful thinking. She stood and moved around the desk, placing a maternal hand on my arm. Promise me you'll think about Helen's offer. It really could be the fresh start you need. I nodded non-committally, allowing her to interpret my response however she chose. I'll certainly keep it in mind. Good, Patricia said, satisfied that she'd done her duty as a concerned mother-in-law. Now let's rejoin the party. I think Mr. Cole wanted to meet you. We returned to the living room, where most of the guests were gathered around the fireplace, enjoying after-dinner drinks and continuing their discussions about Austin politics and social changes. Patricia guided me toward a distinguished man in his 50s wearing an expertly tailored suit and gold-rimmed glasses. Benjamin, I'd like you to meet my daughter-in-law, Natalie, Patricia said warmly. Natalie, this is Benjamin Cole. He's one of Austin's most respected attorneys. Miss Cole extended his hand with a professional smile. Pleasure to meet you, Natalie. Patricia tells me you have some background in law. Some, I agreed, shaking his hand and noting the slight callus on his index finger from years of writing legal briefs by hand before transitioning to computer. Benjamin handles most of the serious legal work for families in our social circle, Patricia explained proudly. Corporate law, estate planning, family court matters. If you need real legal expertise, Benjamin is the person to call. Mr. Cole chuckled modestly. Patricia is too kind. Though I have been practicing for nearly 30 years now, started right out of law school and worked my way up through the ranks at Henderson, Morrison & Associates. That's impressive, I said sincerely. 30 years of practice must give you tremendous insight into how the legal system really works. It does, he agreed, especially in family court, where you really need someone who understands the judges and how they think. The current family court system in Travis County has some excellent judges, but it also has some newer appointments that concern me. Patricia leaned forward with interest. Oh, you mean that new woman judge, the one who replaced Judge Harrison? Mr. Cole nodded gravely. Judge Harper. I'm sure she's a nice person, but she lacks the experience necessary for such an important position. Family court requires seasoned judgment, not someone who's been practicing law for barely 5 years. The irony of the moment wasn't lost on me, as I stood there listening to Miss Cole critique Judge Harper's qualifications while Patricia nodded in agreement. Here was a man who would likely be appearing in my courtroom within the next few weeks, expressing his professional opinion about my competence to handle the cases he would be presenting. Have you appeared before her yet? I asked with genuine curiosity. Not yet, but I have colleagues who have, and the feedback is mixed at best, Mr. Cole replied. She seems to focus too much on emotional factors rather than strict legal precedent. That's fine for a therapist, but in family court you need someone who understands that the law is the law. David appeared at my elbow, having extracted himself from a conversation about golf tournament schedules. How's everyone doing over here? He asked, though I could see the tension around his eyes that suggested he was monitoring the situation carefully. We were just discussing the challenges facing the legal system, Patricia explained. Benjamin was telling us about the new family court judge who doesn't seem quite ready for the responsibility. Judge Harper, Mr. Cole added for David's benefit. I'm sure you've heard about her appointment. Rather controversial, given her limited experience. David's expression remained carefully neutral. I haven't followed the details closely, he said diplomatically. Well, you should, Patricia advised. These judicial appointments affect everyone in the community. We need judges who understand real-world consequences, not idealistic young lawyers who think they can change everything overnight. The conversation continued for another 20 minutes, with various guests joining and leaving the circle as they discussed their concerns about judicial appointments, legal system reforms, and the general decline in professional standards they perceived in modern society. Through it all, I listened and observed, mentally cataloging every comment and opinion expressed about my qualifications, experience, and fitness for the bench. As the evening wound down and guests began to leave, Patricia made sure to remind me about Helen's job offer one more time. Don't wait too long to call her, she advised while David retrieved our coats from the upstairs bedroom. Good opportunities don't last forever, and at your age, you really need to start thinking seriously about your future. The drive home was quiet, with David concentrating on navigating the winding roads that led from his mother's neighborhood back to our downtown apartment. Finally, as we stopped at a red light, he broke the silence. I'm sorry about tonight, he said quietly. She doesn't mean to be cruel, but sometimes she just doesn't think before she speaks. I looked out the passenger window at the familiar streets of Austin, thinking about tomorrow's court calendar and the families who would be depending on my judgment to help them navigate some of the most difficult moments of their lives. It's fine, I said finally. Really, tomorrow is going to be a very interesting day. The morning sun streamed through our downtown apartment windows as I prepared for another day at the Travis County Courthouse. David had already left for an early client meeting, kissing me goodbye while I stood at the bathroom mirror, carefully applying the understated makeup that had become part of my judicial uniform. The black robe hanging on the bedroom door seemed to mock the memory of last night's humiliations, but I pushed the thought aside and focused on the day ahead. My path to the bench hadn't been conventional, and Patricia's assumptions about my career trajectory weren't entirely without basis in her limited understanding of my journey. 3 years ago, when David and I were newlyweds, I had indeed been struggling to establish myself in Austin's competitive legal market. Fresh out of law school with substantial student debt and no family connections to open doors, I'd taken a position with Morrison, Keller & Associates, a mid-sized firm that specialized in family law but paid associates barely enough to cover rent in a decent neighborhood. The work was demanding and often heartbreaking. I represented parents fighting for custody of their children, spouses seeking protection from domestic violence, and families navigating the complex emotional and financial aftermath of divorce. The hours were brutal, frequently extending into evenings and weekends as I prepared for hearings, interviewed clients, and researched precedents that might help families find some measure of justice in their darkest moment. Patricia had been vocal in her disapproval of my schedule from the beginning. During our first Christmas as a married couple, she'd cornered me in her kitchen while I was helping prepare dinner, demanding to know why I couldn't find a normal job with reasonable hours that would allow me to attend family functions and social events, without constantly checking my phone for urgent messages from clients. David needs a wife who can support his career advancement, she'd said while arranging canapes on a crystal platter. These legal firms take advantage of young associates, especially women. They know you'll work twice as hard for half the recognition because you're trying to prove something. I tried to explain that family law wasn't just a job for me, that the work felt meaningful in ways that transcended typical career considerations. Every successful custody modification meant a child would be safe. Every protective order meant a victim of domestic violence could sleep without fear. Every mediated settlement meant a family could move forward without the trauma of a contentious trial. But Patricia had dismissed these explanations as naive idealism. You can't save everyone, Natalie, she'd said with the tone of someone delivering uncomfortable but necessary truth. And you certainly can't build a stable marriage on good intentions and 60-hour workweek. The irony was that Patricia's criticism had inadvertently motivated me to work even harder. Determined to prove that I could excel in the legal profession while maintaining a strong marriage, I began taking on additional pro bono cases, volunteering for continuing education seminars, and building relationships with other family law attorneys who could provide mentorship and guidance. Judge Harrison noticed my work during a particularly complex custody case involving allegations of parental alienation. I'd spent weeks preparing expert witness testimony and researching psychological evaluations, ultimately presenting a case that helped the court understand the subtle but devastating ways children could be manipulated during divorce proceedings. After the hearing, Judge Harrison had approached me in the courthouse hallway. "Miss Harper," he'd said, "that was exceptional advocacy. Your preparation and presentation helped me make a decision that will genuinely serve this child's best interests." That conversation had led to others. Judge Harrison began recommending me for more complex cases, and my reputation within Austin's family law community grew steadily. When the Judicial Nominating Committee began considering candidates to replace Judge Harrison upon his retirement, my name appeared on the list alongside two other attorneys with significantly more years of practice, but less specialized experience in family court matters. The nomination process had been exhaustive. Hours of interviews with committee members who questioned every aspect of my legal education, professional experience, and judicial philosophy, written examinations on constitutional law, family court procedures, and ethical consideration, reference checks with former clients, opposing counsel, and legal colleagues who could speak to my character and competence. Throughout the months-long process, I'd been careful not to discuss the nomination with anyone outside my immediate family. The legal community in Austin was small and interconnected, and premature disclosure of my candidacy could have created uncomfortable situations with colleagues or clients who might have strong opinions about judicial appointment. David had been incredibly supportive, understanding that the demands of the nomination process meant even longer hours and more stress than my already challenging work schedule. He'd handled Patricia's complaints about my continued absence from family gatherings, deflecting her criticism without revealing the reason for my increased professional obligations. When the appointment was announced, David had been the first person I'd called. His excitement and pride had been genuine and overwhelming, and for a moment, I'd forgotten about Patricia's persistent disapproval of my career choices. "We have to tell Mom," David had said immediately after we'd finished celebrating with champagne in our apartment. "She's going to be so proud." A federal judge in the family, I'd corrected him gently, explaining that I would be serving as a district court judge, not a federal appointment, but his enthusiasm hadn't dimmed. We'd planned to share the news at Sunday dinner the following week, anticipating Patricia's surprise, and hopefully her recognition that her concerns about my career stability had been unfounded. But that Sunday dinner had been complicated by Patricia's announcement that she'd invited the Whitman family to join us, turning what should have been an intimate family celebration into a larger social gathering where personal news felt inappropriate to share. The following Sunday had brought similar complications, and soon the momentum of the moment had passed. As weeks turned into months, it became increasingly awkward to announce news that was no longer fresh. Patricia's continued criticism of my professional life made the revelation feel defensive rather than celebratory, and David and I had eventually agreed to wait for the right opportunity to share the appointment naturally. That opportunity had never materialized, partly because Patricia rarely asked direct questions about my work, preferring to make assumptions based on her limited observations of my schedule and social availability. When I declined invitations to afternoon social events or evening charity functions, she concluded that I was unemployed and therefore had no legitimate excuse for avoiding family obligations. The morning routine in chambers had become familiar and comforting. My clerk, Jennifer Rodriguez, would arrive by 7:30 to review the day's calendar and highlight any cases that might require additional preparation or research. Jennifer was a seasoned professional who'd worked in family court for over a decade, and her insights into case management and court procedures had been invaluable during my transition to the bench. "Good morning, Judge Harper," Jennifer greeted me as I settled behind my desk with coffee and the case files for the day's hearings. "We have the Morrison custody modification at 9, the protective order hearing at 10:30, and the settlement conference for the Patterson divorce at 2. I reviewed my notes from the previous hearings in each case, refreshing my memory of the family dynamics and legal issues involved. The Morrison case was particularly complex, involving a father's request to modify custody arrangements after his ex-wife's remarriage to a man with a history of substance abuse. The protective order hearing involved allegations of stalking and harassment that would require careful evaluation of evidence and testimony from both parties. The Patterson Settlement Conference represented the kind of work I found most rewarding about family court service. Rather than making adversarial rulings that left both parties feeling defeated, settlement conferences allowed me to help families find mutually acceptable solutions to their disputes while avoiding the emotional and financial costs of prolonged litigation. Also, Jennifer continued, consulting her notes, "Attorney Cole's office called this morning. He's requesting a meeting to discuss the Henderson case before it's scheduled. Apparently there are some procedural issues he'd like to address. Benjamin Cole, the same attorney who'd spent 20 minutes at Patricia's party explaining why I was unqualified for my position. The Henderson case was a contentious custody dispute involving significant assets and complex questions about parental fitness. Cole represented the father, a successful businessman who claimed his ex-wife was emotionally unstable and potentially dangerous to their 2 young children. Schedule the meeting for Thursday afternoon, I decided, and make sure we have the complete case file available for review beforehand. The irony of the situation wasn't lost on me. In 3 days, Benjamin Cole would be sitting in my chambers, making legal arguments and requesting judicial rulings from the same inexperienced judge he'd criticized so thoroughly at Patricia's birthday celebration. I wondered if he would recognize me from the party, though given his dismissive attitude toward Patricia's unemployed daughter-in-law, he might not have paid enough attention to remember my face. The morning hearings proceeded smoothly. The Morrison custody modification required careful questioning of both parents and the court-appointed psychologist who'd evaluated the family situation. After 2 hours of testimony and evidence review, I granted the father's request for supervised visitation between the children and their stepfather, while maintaining the existing custody arrangement between the biological parents. The protective order hearing was more straightforward but emotionally intense. The petitioner, a young woman named Amanda Stevens, had been receiving increasingly threatening messages and unwanted visits from her ex-boyfriend after their breakup 6 months earlier. Her testimony was compelling and credible, supported by text message evidence and witness statements from neighbors who'd observed the respondent's behavior. The respondent's attorney attempted to characterize the situation as a misunderstanding between former lovers who needed time and space to heal from their relationship's end. But the pattern of escalating contact, despite Stevens's clear request to be left alone, suggested something more troubling than simple heartbreak. Mr. Thompson, I addressed the respondent directly, do you understand that Miss Stevens has repeatedly asked you not to contact her or visit her workplace and residence? Yes, Your Honor, he replied, his voice barely audible, but we were together for 2 years. I just wanted to talk to her, to try to work things out. The time for working things out ended when Miss Stevens made her wishes clear, I explained firmly. Continuing to contact someone who has explicitly asked you to stop is not romantic persistence. It's harassment, and in this case it's created a genuine fear for Miss Stevens' safety. I granted the protective order for a period of 2 years, with provisions that Ms. Thompson maintain no contact with Miss Stevens through any means, including social media, third-party intermediaries or surprise visits to locations where she might be present. During the lunch break, I walked to the small cafe across the street from the courthouse, a routine that helped me decompress between morning and afternoon sessions. The cafe was popular with attorneys, court staff and downtown office workers, but the lunch rush meant I could usually find a quiet corner table where I could review notes or simply enjoy a few minutes of solitude. Today, however, my solitude was interrupted by a familiar voice from the table behind mine. The problem with these newer judges is that they don't understand the difference between law and social work. Someone was. Family court is supposed to be about legal precedent, not therapeutic intervention. I recognized the voice as belonging to Margaret Foster, Patricia's bridge partner from last night's party. She was having lunch with 2 other women I didn't recognize, but their conversation was clearly focused on recent changes in the local court system. My neighbor's daughter went through a custody battle last year, one of Margaret's companions was saying. She said the judge spent more time asking about feelings than focusing on the legal facts of the case. That's exactly what I'm talking about, Margaret replied. These appointments are political now. They're choosing people based on demographics rather than qualification. I continued eating my salad while listening to their critique of modern family court practice. Margaret's perspective wasn't uncommon among certain segments of Austin's social establishment, particularly those who preferred traditional approaches to legal proceedings that prioritized formal procedures over the human impact of judicial decisions. The truth was that family court had evolved considerably over the past 2 decades, incorporating research from child psychology, domestic violence prevention, and family systems therapy into legal decision-making process. Modern family court judges were expected to understand not just legal precedent, but also the complex dynamics that affected children's well-being during custody disputes and the long-term consequences of various custody arrangements on family relations. This evolution hadn't occurred without controversy. Some attorneys and judges preferred the older model of family court, where decisions were based primarily on financial considerations and formal legal standards, rather than psychological evaluations and therapeutic intervention. The tension between these approaches sometimes created conflicts between traditional legal practitioners and newer judges who embraced more holistic approaches to family law. Patricia Harper was telling me about her daughter-in-law last night, Margaret continued. Sweet girl, but completely lost professionally. Patricia's been trying to help her find direction, but some people just aren't cut out for demanding careers. Her companion made a sympathetic noise. It's hard when family members can't contribute equally to the partnership. Patricia's son must feel tremendous pressure carrying the financial responsibility alone. I finished my salad and gathered my belongings, leaving the cafe without acknowledging Margaret or her companion. The afternoon settlement conference was scheduled to begin in 30 minutes, and I wanted to review the Patterson case file one more time before the session started. The Patterson divorce involved a couple in their 40s who'd built a successful catering business together during 15 years of marriage. The business assets were substantial, but more importantly, both parties wanted to continue operating the company after their divorce was finalized. The challenge was creating a buyout arrangement that would allow one spouse to maintain control of the business while ensuring fair compensation for the other's contributions to its success. David Patterson was represented by a senior attorney from one of Austin's most prestigious firms, while his wife Sarah had hired a solo practitioner who specialized in small business divorces. The disparity in legal representation sometimes created imbalances in settlement negotiations, but both attorneys had been professional and prepared throughout the proceeding. The settlement conference took place in my chambers rather than the formal courtroom, creating a more relaxed atmosphere that encouraged open discussion of potential solutions. David and Sarah Patterson sat at opposite ends of the conference table, their attorneys flanking them, while I occupied the neutral position at the head of the table. Before we begin discussing specific terms, I addressed both parties. I want to emphasize that today's goal is finding a solution that allows both of you to move forward with dignity and financial security. You've built something valuable together, and the end of your marriage doesn't have to mean the destruction of that achievement. Sarah Patterson spoke first, her voice steady despite the obvious emotional difficulty of the situation. The business has been my life for 15 years. I developed most of our signature recipes, built relationships with our key clients, and managed the day-to-day operations while David handled the financial side. Her husband shifted uncomfortably in his chair. Sarah's contributions have been significant, he acknowledged, but the business expansion over the past 5 years has been primarily due to my investment strategies and marketing decisions. The company's current value reflects my leadership during our most profitable period. The competing narratives were common in small business divorces. Both parties had legitimate claims to the company's success, and both had reasonable arguments for why they should retain primary control after the divorce. The challenge was finding a solution that honored both contributions, while creating a practical framework for the business's continued operation. After 3 hours of discussion, negotiation and occasional tension, we reached an agreement that satisfied both parties' primary concern. Sarah would retain ownership of the catering company, including all recipes, client relationships, and operational systems. David would receive a buyout payment equivalent to 60% of the business's appraised value, paid over 4 years with interest, plus a consulting agreement that would allow him to remain involved in financial planning for 2 additional years. The settlement also included provisions for both parties to sign non-compete agreements preventing either from starting rival catering businesses in Austin for 3 years, protecting the value of the company that Sarah would be operating independently. This agreement represents a fair resolution that allows both of you to pursue your post-divorce goals without ongoing conflict, I concluded as both attorneys reviewed the final terms. Ms. Patterson, you'll be able to continue operating the business you've helped build, and Ms. Patterson, you'll have the financial resources to pursue new opportunities while maintaining some connection to the company's success. Both parties signed the settlement agreement that afternoon, avoiding the need for a contested trial that could have taken months to resolve and cost both of them significantly more in legal fees and emotional stress. The day ended with a brief meeting with Jennifer to review the next day's calendar and discuss scheduling conflicts for the following week. The Henderson case, where I would be facing Benjamin Cole's arguments about my qualifications, was now confirmed for Thursday afternoon. Judge Harper, Jennifer said as we finished reviewing the case files, I wanted to mention that you've received several complimentary letters from attorneys who've appeared before you recently. The Bar Association feedback has been consistently positive. She handed me a folder containing copies of evaluation forms that attorneys were required to submit after appearing in family court. The The comments were gratifying to read. Judge Harper demonstrates excellent preparation and asks insightful questions that help clarify complex issues. Her settlement conferences are efficient and productive. She maintains appropriate courtroom decorum while showing genuine concern for the families involved. The professional recognition felt particularly meaningful in light of last night's social humiliation. Patricia and her friends might question my qualifications based on their limited understanding of my career, but the legal community that worked with me daily had a very different perspective on my competence and contribution to Austin's family court system. The drive home took me through the same Westlake Hills neighborhood where Patricia lived, and I found myself thinking about the contrast between my public and private life. In chambers, I was Judge Harper, a respected member of the judiciary, whose decisions affected real families facing genuine crises. At Patricia's dinner parties, I was the disappointing daughter-in-law whose career instability reflected poorly on her son's judgment in choosing a spouse. David was waiting when I arrived at our apartment, having prepared dinner and opened a bottle of wine to accompany our evening together. The normalcy of our domestic routine felt comforting after the day's professional challenges and the lingering tension from last night's social gathering. "How was court today?" he asked as we sat down to eat the pasta he'd prepared with fresh vegetables from the farmer's market. "Productive," I replied, describing the successful settlement conference and the satisfaction of helping a divorcing couple find a mutually acceptable solution to their business partnership dispute. "Sometimes I think settlement conferences are more rewarding than trial. Everyone leaves feeling like they've been heard and treated fairly." David smiled, understanding my enthusiasm for the collaborative aspects of family court work. He'd listened to similar descriptions of successful mediations and settlement agreements throughout our marriage, and he genuinely shared my belief that the legal system could be a positive force in helping families navigate difficult transitions. "Mom called this afternoon," he said carefully, his tone suggesting that the conversation had been challenging. "She wanted to follow up on her job offer for you yesterday." I set down my wine glass and waited for him to continue. "She's concerned that you might be too proud to accept help, and she wanted me to encourage you to consider Helen's interior design position seriously. She thinks it could be a good stepping stone to more substantial employment." The conversation was predictable, but it still stung to realize that Patricia's assessment of my professional situation was so completely detached from reality. Her genuine desire to help me find meaningful work was touching in its way, even though it was based on fundamental mental misunderstandings about my actual career status. "What did you tell her?" I told her that you're capable of making your own career decisions, and that she should trust your judgment about what's best for our family," David replied. "But you know how she is. She thinks silence means agreement, so she's probably interpreting my response as confirmation that you need her intervention." We finished dinner while discussing David's day at the advertising agency, where he was working on a campaign for a local restaurant chain that wanted to expand into the Dallas market. His work was creative and demanding, requiring long hours and frequent client meetings, but it also provided the financial stability that allowed us to live comfortably in downtown Austin while I established myself in the legal profession. Later that evening, as I reviewed case files for the next day's hearings, I found myself thinking about Thursday's meeting with Benjamin Cole. In 3 days, the attorney who'd dismissed my qualifications at Patricia's party would be sitting in my chambers, making legal arguments and requesting judicial decisions that could significantly impact his client's family. The situation presented an interesting ethical consideration. Ms. Cole's comments about my competence had been made in a social setting, not in a professional context, and they reflected his general opinion about judicial appointments rather than any specific criticism of my handling of his cases. As long as I could evaluate his legal arguments objectively, and make decisions based on law and evidence, rather than personal feelings about his social commentary, there was no conflict of interest that would require my recusal from the case. Still, I was curious to see whether he would recognize me from the party, and if so, how he would handle the awkwardness of having criticized a judge to her face without realizing her identity. The professional legal community in Austin was small enough that most attorneys eventually appeared before most judges, but the social overlap between the courthouse and Patricia's dinner parties was less common. Thursday would bring an interesting test of everyone's professionalism, including my own ability to separate my judicial responsibilities from the personal slights I'd endured as Patricia's disappointing daughter-in-law. The law required me to evaluate Miss Cole's arguments on their merits, regardless of his social opinions about my qualifications, and I intended to fulfill that obligation completely. But I was also looking forward to the moment when he realized that the unqualified judge he'd criticized so thoroughly was the same woman who'd stood quietly in Patricia's living room, listening to his professional assessment of her competence, while sipping wine and fighting back the urge to smile. Benjamin Cole was at your birthday party Monday night, I said carefully, watching Patricia's expression shift from confusion to dawning horror. He spent considerable time explaining to your guests why he thought Judge Harper was unqualified for the position. Patricia's face went pale as the full implications of the situation became clear. Not only had she publicly criticized her daughter-in-law's non-existent career problems, but she'd provided a platform for her attorney friend to disparage the same daughter-in-law's actual professional qualifications to a room full of their mutual acquaintance. "Oh my God," she whispered, pressing her fingers to her temples. "Benjamin was talking about you. All that time he was criticizing you, and you were standing right there." David reached across the table to touch his mother's hand. "Mom, it's okay. These things happen when people make assumptions instead of asking questions." But Patricia was already spiraling into the kind of social panic that consumed people who prided themselves on maintaining perfect appearances within their community circle. Her reputation as someone who knew everyone's business, and always had the inside information on local developments, had just been shattered by her spectacular ignorance of her own family's achievements. "Everyone at the party heard him say those things," she continued, her voice barely audible. "Margaret Foster, the Whitmans, Robert Chen, Carol Thompson, they all heard Benjamin question your experience and competence." The social mathematics of her embarrassment were complex and devastating. Patricia had built her identity around being well-informed about Austin's professional and social hierarchies, and her failure to recognize her daughter-in-law's prominent position in the legal community represented a fundamental collapse of her carefully cultivated image. "What must they think of me now?" she asked rhetorically. "When they find out that I didn't even know my own daughter-in-law was a judge, they'll think I'm completely out of touch." I felt a pang of sympathy for Patricia's distress, even though her embarrassment was entirely self-inflicted. Her anxiety about social appearances had always been one of her defining characteristics, and this situation threatened the very foundation of her identity within Austin's upper-middle-class community. "Patricia," I said gently, "people will understand that family situations can be complicated. You're not the first mother-in-law who's been confused about her children's career developments." She looked at me with an expression that suggested my attempt at reassurance had missed the mark entirely. "Natalie, you don't understand. These people expect me to know what's happening in my own family. They come to me for information about legal matters, political appointments, and professional developments, because they think I have inside knowledge." Our lunch arrived, providing another brief interruption to the increasingly intense conversation. Patricia barely acknowledged her salad, instead continuing to process the social implications of her mistake while David and I attempted to eat our meals in the uncomfortable atmosphere that had developed around our table. "How long have people known about your appointment?" Patricia asked suddenly. "I mean people in the legal community and the social circles that overlap with mine." The question revealed another layer of her anxiety. Not only had she been ignorant of my professional status, but other people in her social network had likely known about my judicial appointment while she remained unaware of her own family's achievements. "The appointment was announced in the Austin American-Statesman last year," I explained. "There was also coverage in the Texas Bar Journal and the Travis County legal publications. Most attorneys and judges in the area would have been aware of the transition from Judge Harrison to Judge Harper." Patricia's expression suggested she was calculating how many of her acquaintances had known about my judicial appointment, while listening to her criticize my employment situation at social gatherings over the past 12 months. "Ms. Chen mentioned that her husband practices some family law," David added helpfully. "He would have definitely known about Natalie's appointment." This information seemed to deepen Patricia's distress rather than providing any comfort. "So Robert knew who Natalie was when I was talking about her career problems at the party. He knew and he didn't say anything." The social dynamics of the situation were indeed complex and potentially embarrassing for everyone involved. Patricia's friends had found themselves in the awkward position of listening to her criticize someone whose professional achievements they likely respected, but social courtesy had prevented them from correcting her misconceptions directly. "They probably didn't know how to handle the situation," I suggested diplomatically. Correcting someone's statements about their family member's career would have been socially complicated, especially at a birthday celebration. But Patricia wasn't comforted by this explanation. Instead, she seemed to be visualizing every conversation she'd had over the past year, where she'd mentioned my employment struggles to people who knew the truth about my judicial appointment. "The Bridge Club," she said suddenly. "I've been talking to the Bridge Club about your situation for months. Margaret Foster, Helen Williams, Carol Thompson, they must have known." The Bridge Club represented Patricia's primary social outlet and information network. Her weekly games with the same group of women provided opportunities to share gossip, discuss community developments, and maintain social connections that were important to her identity within Austin's established circle. I told them about Helen's job offer for you just last week, Patricia continued, her voice rising slightly with mounting embarrassment. I presented it as this wonderful opportunity for you to finally get some professional direction, and they probably all knew you were already a sitting judge. David attempted to redirect the conversation toward more constructive territory. Mom, the important thing is that we're clarifying the situation now. People will understand that family communication can be complicated, and they'll respect your willingness to acknowledge the But Patricia was beyond reassurance at this point. Her mind was clearly cataloging every social situation where she'd discussed my career struggles with people who had better information than she possessed about her own family's professional achievement. The Country Club Charity Committee, she said, apparently working through a mental list of her social obligations. I'm co-chairing the legal aid fundraiser next month, and I've been presenting myself as someone who understands the challenges facing underemployed attorneys in our community. The irony of Patricia's involvement in legal aid fundraising while being unaware of her daughter-in-law's judicial appointment was profound, though I tried not to focus on the humor in her situation given her obvious distress. Your work with legal aid is valuable regardless of this misunderstanding, I pointed out. Supporting legal services for people who can't afford attorneys is important community work. Patricia looked at me with an expression that suggested she was beginning to understand additional implications of my professional status that went beyond her immediate social embarrassment. You could have helped with the fundraiser, she said slowly. A sitting judge supporting legal aid would have been a significant endorsement for our efforts. This realization seemed to shift Patricia's focus from pure embarrassment toward regret about missed opportunities for community involvement and professional collaboration. She was beginning to understand that her misconceptions about my career had prevented potential partnerships that could have benefited both her charitable work and my professional relation. I would have been happy to support the legal aid fundraiser if I'd known about your involvement, I assured her. There are still opportunities for collaboration if you're interested. But Patricia was already moving on to other implications of the situation that were occurring to her as she processed the full extent of her misunderstanding. Benjamin Cole, she said suddenly. He's appearing before you in court case. How is he handling the professional relationship after what happened at the party? This question touched on one of the more complex aspects of the situation. Benjamin Cole's criticism of my judicial qualifications had been delivered in a social context, but it created potential awkwardness in our professional interactions that required careful navigation to maintain appropriate courtroom decorum. Mr. Cole is a competent attorney who presents his cases professionally, I replied diplomatically. Our working relationship in court is based on legal arguments and evidence, not social conversation. Patricia studied my expression, apparently trying to determine whether there were additional complications I wasn't discussing. But he must be embarrassed about what he said at the party. Probably, I agree. Though professional attorneys are accustomed to separating their personal opinions from their courtroom responsibility. David had been listening to this exchange while finishing his lunch, and he chose this moment to share additional information that would further complicate Patricia's understanding of the social dynamics involved. Ben called my office yesterday to discuss some marketing work, David said carefully. During the conversation, he asked about Natalie's career, and seemed surprised to learn about her judicial appointment. Patricia's eyes widened as she processed this new information. He didn't recognize her, even after spending an hour criticizing her qualifications while she was standing right there. Apparently not, David confirmed. He remembered meeting her at the party and was impressed by her intelligence, but he didn't connect her with Judge Harper until I told him about her appointment. This revelation added another layer to Patricia's embarrassment. Not only had she provided a platform for someone to criticize my professional qualifications, but the critic had been so dismissive of my presence that he hadn't even bothered to remember my face or name well enough to recognize me in a professional context. So Benjamin spent Monday afternoon arguing cases before a judge whose competence he'd questioned publicly just 4 days earlier, and he didn't even realize it, Patricia summarized. That's correct, I confirmed. Patricia was quiet for several minutes, apparently contemplating the various social and professional complications that had resulted from her assumptions about my career status. When she finally spoke again, her tone had shifted from embarrassment towards something that resembled genuine curiosity about my professional life. What kind of cases do you handle as a family court judge? She asked. The question suggested that Patricia was beginning to move beyond her immediate social concerns toward actual interest in understanding my judicial responsibilities. I spent the next few minutes describing the types of custody disputes, divorce proceedings, and protective order hearings that filled my daily calendar. Patricia listened attentively as I explained the complexities of modern family law, the psychological evaluations required in custody cases, and the collaborative approaches that contemporary family courts use to help families navigate difficult transitions. Her questions became more sophisticated as the conversation progressed, suggesting that she was genuinely trying to understand the professional expertise required for judicial service in family court. "It sounds incredibly demanding," she said when I'd finished describing a typical week's caseload, "both intellectually and emotionally." "It is," I agreed. "But it's also deeply rewarding when you can help families find solutions that protect children's well-being while respecting parents' rights and responsibilities." Patricia nodded thoughtfully, apparently beginning to appreciate the significance of my professional appointment and the specialized knowledge required for effective judicial service in family court matters. "I owe you an apology," she said finally, "not just for the misunderstanding about your career, but for never taking the time to ask informed questions about your work or showing interest in your professional achievement." The apology was gracious and seemed genuine, though I could see that Patricia was still processing the full implications of the situation and her role in creating the social complications that had developed around my judicial appointment. "I appreciate that," I replied. "But I think we also need to discuss how to handle the social aspects of this situation, particularly with the people who were at your birthday party." Patricia's expression suggested that she'd been dreading this part of the conversation. The prospect of addressing her mistake with friends and acquaintances who'd witnessed her criticism of my career represented the kind of social challenge that she found most difficult to navigate. "What do you think I should do?" she asked. David and I exchanged glances before I responded. We'd discussed this question during our drive to the restaurant, anticipating that Patricia would need guidance on managing the social fallout from her misconceptions about my professional status. "I think the best approach is straightforward acknowledgement," I suggest. "Contact the people who were at the party, explain that there was a misunderstanding about my career, and share the correct information about my judicial appointment." Patricia looked uncomfortable with this suggestion, probably because it required her to admit ignorance about her own family's achievements to people whose opinions she valued highly. "What if they think less of me for not knowing something so basic about my daughter-in-law's career?" she asked. "They might," David said honestly, "but they'll think less of you if they discover the truth through gossip rather than from you directly." This practical consideration seemed to resonate with Patricia's understanding of social dynamics. Her reputation for being well-informed about community developments would be damaged more severely if people learned about her mistake through other sources rather than through her own acknowledgement of the misunderstanding. "I suppose I could call Margaret and explain the situation," Patricia said tentatively. "She could help me figure out how to approach the other people who were at the party." Margaret Foster, as Patricia's closest friend and bridge partner, would indeed be a logical person to consult about managing the social implications of the situation. Her advice would probably be practical and focused on minimizing long-term damage to Patricia's reputation within their social circle. "That sounds like a good starting point," I agreed. Our server returned to refill our coffee cups and ask about dessert, providing another brief interruption to the intense conversation. None of us had much appetite for dessert given the emotional weight of our discussion, but we all accepted coffee refills while continuing to process the various implications of the situation. "There's something else we need to discuss," Patricia said after our server left. "Your work schedule and social obligations." I waited for her to continue, sensing that this topic might be complicated. "I've been criticizing your availability for family events and social gatherings without understanding that you have genuine professional responsibilities that limit your flexibility," she continued. "I owe you an apology for that as well." The acknowledgement was gratifying, though it also highlighted how Patricia's misconceptions about my career had affected our family relationships over the past year. Her criticism of my attendance at social events had been based on the assumption that I was unemployed and therefore had no legitimate excuse for missing family obligations. "Judicial schedules can be demanding," I explained. "Court sessions, case preparation, and continuing education requirements don't always align with social calendars." Patricia nodded understandingly. "I should have asked about your schedule conflicts instead of assuming you were being antisocial or uninterested in family relationships." David reached across the table to squeeze his mother's hand. "Mom, the important thing is that we're having this conversation now and clearing up all these misunderstandings." But Patricia still seemed troubled by additional aspects of the situation that were occurring to her as we talked through the various implications of my judicial appointment. "What about Benjamin's legal practice?" she asked, suddenly. "If he's been critical of your qualifications in social settings, does that create conflicts of interest when he appears before your court?" The question demonstrated that Patricia was beginning to understand the professional complexities that extended beyond the immediate social embarrassment of the situation. Professional attorneys are expected to separate their personal opinions from their courtroom advocacy, I explained. As long as Mr. Cole can present his client's cases based on legal merit rather than personal feelings about judicial appointments, there's no conflict of interest that would require my recusal. Patricia looked skeptical, but it must be awkward for both of you. Professional relationships often involve personal complications that have to be managed appropriately, I replied. The legal system depends on everyone's ability to maintain objectivity despite personal opinions or social interaction. This explanation seemed to satisfy Patricia's concerns about the professional implications of the situation, though I could see that she was still processing the various social complications that would need to be addressed over the coming weeks. The conversation continued for another hour as we worked through the practical aspects of correcting Patricia's misconceptions and managing the social fallout from her public criticism of my career. By the time we left the restaurant, Patricia had committed to calling Margaret Foster that evening to begin the process of clarifying the situation with her social circle. The drive home was quiet, with David and I both reflecting on the emotional intensity of the conversation and the relief of finally addressing the fundamental mental misunderstandings that had complicated our family relationships for the past year. Patricia's apology had been sincere, and her willingness to acknowledge her mistakes suggested that our family dynamics might improve significantly now that everyone understood the actual facts about my professional life. But the social implications of the situation would continue to unfold over the coming weeks as Patricia worked to correct her misconceptions with friends and acquaintances who'd been exposed to her criticism of my career. The bridge club conversations, country club encounters, and professional networking events would all require careful navigation as Austin's interconnected social and professional communities processed the news about Judge Harper's family connection. Monday morning would bring additional complications as Benjamin Cole appeared before my court for the Henderson custody hearing, now fully aware that he'd spent considerable time criticizing my judicial qualifications directly to my face at a social gathering. The professional dynamics of that interaction would test both our abilities to maintain appropriate courtroom decorum despite the personal awkwardness of our previous encounter. The weekend ahead would provide time for everyone to process the revelations and prepare for the social and professional adjustments that would be necessary, as the truth about my judicial appointment became more widely known throughout Austin's legal and social community. Monday morning arrived with the kind of crisp energy that made downtown Austin feel alive with possibility. I arrived at chambers earlier than usual, knowing that the Henderson custody hearing would be one of the most professionally challenging cases of my judicial career, complicated by the personal dynamics between Benjamin Cole and myself following our awkward social encounter at Patricia's birthday party. Jennifer had already arranged the complete case file on my desk, along with fresh coffee and the morning's court calendar. The Henderson hearing was scheduled for 10 o'clock, giving me time to review the psychological evaluations, financial records, and witness statements one final time before Benjamin Cole and Maria Santos presented their competing arguments about the children's best interest. Judge Harper, Jennifer said as she entered my chambers. Attorney Cole arrived early and is waiting in the conference room. He requested a brief meeting before the hearing began. I nodded, understanding that Benjamin Cole probably wanted to address the personal awkwardness of our situation before we proceeded with the formal custody proceeding. Professional courtesy required that we acknowledge the elephant in the room and establish ground rules for maintaining appropriate courtroom decorum despite our social complications. Please show him in, I instructed, straightening my judicial robes and reviewing my notes one final time. Benjamin Cole entered my chambers with an expression that clearly conveyed his embarrassment about the events of the previous week. His usual confident demeanor had been replaced by something more humble and apologetic, suggesting that he'd spent considerable time reflecting on his behavior at Patricia's party. Judge Harper, he began formally, I want to apologize for my inappropriate comments at Miss Harper's birthday celebration. My criticism of your qualifications was unprofessional and based on incomplete information. The apology was straightforward and seemed genuine, though I could see the personal discomfort he felt about having to address his social mistake in a professional setting. Mr. Cole, I replied diplomatically, I appreciate your acknowledgement of the situation. However, I want to assure you that my evaluation of your legal arguments will be based solely on their merit and relevance to the Henderson case, not on any personal interactions we may have had in social settings. He nodded gratefully. Thank you, Your Honor. I have complete confidence in the court's objectivity and professionalism. The brief exchange established the boundaries we both needed to proceed with the custody hearing in an appropriate manner. Benjamin Cole could present his client's case without worrying about personal retribution for his social comments, and I could evaluate his legal arguments based on their substance rather than any lingering irritation about his criticism of my qualification. Is there anything else you need to address before we begin the hearing? I asked. No, Your Honor, he replied. I'm prepared to present Mr. Henderson's case for primary custody based on the evidence and legal precedent we discussed in our previous meeting. The Henderson custody hearing lasted nearly 4 hours, with both attorneys presenting thorough arguments supported by expert testimony, financial records, and psychological evaluation. Benjamin Cole's advocacy for his client was competent and well prepared, focusing on Robert Henderson's financial stability, consistent parenting practices, and the children's educational opportunity. Maria Santos presented an equally compelling case for Lisa Henderson, emphasizing her emotional connection with the children, her flexibility in accommodating their changing needs, and her commitment to maintaining relationships with both parents despite the divorce proceeding. The psychological evaluation conducted by Dr. Sarah Mitchell provided crucial insights into the family dynamics and the children's adjustment to their parents' separation. Her testimony revealed that both Emma and Michael had strong bonds with both parents but were being negatively affected by the ongoing conflict and uncertainty about their living arrangements. Mitchell, I asked during her testimony, in your professional opinion, what custody arrangement would best serve these children's long-term emotional and developmental needs? She considered the question carefully before responding. Your Honor, both parents demonstrate genuine love and concern for Emma and Michael. However, the children would benefit most from a stable primary residence with one parent, combined with regular, predictable contact with the other parent in an environment free from ongoing conflict. Her recommendation didn't clearly favor either parent, instead emphasizing the importance of reducing uncertainty and conflict regardless of which parent received primary custody. After hearing all the testimony and reviewing the extensive documentation, I announced that I would take the case under advisement and issue a written decision within 10 days. The complexity of the family situation required careful consideration of all factors before determining the custody arrangement that would best serve Emma and Michael's interests. Following the hearing, I spent the remainder of the afternoon reviewing other cases and preparing for Tuesday's court calendar. The professional interaction with Benjamin Cole had proceeded smoothly despite our social complications, demonstrating that legal professionals could indeed separate personal opinions from courtroom responsibilities when necessary. That evening, David shared the results of Patricia's conversations with her social circle over the weekend. Her phone calls to Margaret Foster, Carol Thompson, and other party guests had been emotionally difficult, but ultimately productive in clarifying the situation and beginning to repair her damaged reputation within Austin's social community. Margaret was actually very understanding, David reported as we prepared dinner together in our downtown apartment. She said several people at the party had suspected there was more to Natalie's professional situation than Mom realized, but they didn't know how to address it tactfully. The information confirmed my suspicion that Patricia's friends had been in an awkward position during her birthday celebration, aware of my judicial appointment, but constrained by social courtesy from correcting her misconceptions directly. What about the other? I asked while chopping vegetables for our stir-fry. Mixed reactions, David admitted. Some were understanding about the family communication issues, but others seemed to think Mom should have been better informed about her daughter-in-law's career. The social fallout was predictable, though probably less severe than Patricia had feared during our lunch conversation. Austin's upper-middle-class community was accustomed to managing social complications with grace, and most of Patricia's friends would likely treat the situation as an unfortunate misunderstanding, rather than a devastating social failure. Robert Chen called Mom this afternoon, David continued. He wanted to apologize for not correcting the record at the party, and to express his professional respect for your judicial service. This gesture was particularly gracious, given that Robert Chen could have easily avoided any involvement in the social complications surrounding Patricia's mistake. His willingness to contact her directly suggested that Austin's professional community was prepared to move beyond the awkwardness of the situation. Tuesday morning brought an unexpected development, when Jennifer informed me that Benjamin Cole had submitted a formal letter to the court expressing his professional respect for my judicial service, and withdrawing any concerns he might have previously expressed about my qualifications for the bench. The letter was carefully worded to address his social comments without creating any official record that might complicate future professional interaction. It demonstrated his understanding that public criticism of sitting judges, even in social settings, could potentially undermine the authority and effectiveness of the judicial system. This is unusual but appropriate, Jennifer observed as we reviewed the letter. It shows professional maturity and respect for the court's dignity. I agreed, though I also recognized that Benjamin Cole's letter was motivated partly by his need to protect his own professional reputation within Austin's legal community. Word of his social criticism of a sitting judge had probably reached other attorneys and judges, creating potential complications for his practice if not addressed appropriately. The remainder of the week proceeded normally, with routine hearings, settlement conferences, and case preparation occupying my daily schedule. The social drama surrounding Patricia's party was gradually fading into background noise as Austin's legal and social communities adjusted to the corrected understanding of my professional status. Friday afternoon brought the moment I'd been anticipating since Monday's hearing. I'd reached my decision in the Henderson custody case after careful review of all testimony, evidence, and expert recommendation. The written ruling would be filed with the court clerk and distributed to both attorneys, but I wanted to announce my decision in open court to provide closure for the family. Both attorneys appeared promptly at 2 o'clock, accompanied by Robert and Lisa Henderson, who sat on opposite sides of the courtroom with their respective support systems. The tension in the room was palpable as everyone waited to learn which parent would receive primary custody of Emma and Mike. After careful consideration of all testimony and evidence presented in this matter, I began. The court finds that both parents demonstrate genuine love and concern for their children's welfare. However, the ongoing conflict between Mr. and Miss Henderson has created an unstable environment that is negatively affecting Emma and Michael's emotional development. I paused to allow both parents to process this assessment before continuing with my ruling. Therefore, the court awards joint legal custody to both parents, with primary physical custody granted to Mrs. Henderson and substantial parenting time granted to Mr. Henderson according to the schedule detailed in the written order. The decision represented a compromise that acknowledged both parents' strengths, while prioritizing the children's need for stability and reduced conflict. Lisa Henderson would provide the primary residence, but Robert Henderson would maintain significant involvement in his children's lives through regular overnight visits, shared holidays, and participation in educational and extracurricular activity. Additionally, I continued, both parents are ordered to participate in co-parenting counseling to develop effective communication strategies that prioritize the children's emotional well-being over their personal conflict. The counseling requirement was designed to help Robert and Lisa Henderson learn to separate their marital grievances from their parental responsibilities, creating a healthier environment for Emma and Michael's continued development. Benjamin Cole accepted the ruling professionally, though I could see his disappointment that his client hadn't received the primary custody he'd requested. Maria Santos expressed gratitude for the court's thorough consideration of the complex family dynamics involved in the case. After court adjourned, I spent an hour reviewing the written order one final time before signing it and forwarding copies to both attorneys. The Henderson case represented exactly the kind of complex family situation that made judicial service both challenging and rewarding, requiring careful balance between competing interests and long-term thinking about children's developmental needs. That evening, David and I attended a reception at the Austin Bar Association celebrating recent judicial appointments and recognizing outstanding service in the legal community. The event provided an opportunity to interact with colleagues in a relaxed social setting while celebrating the contributions of legal professionals to Austin's justice. Patricia had been invited to attend as my guest, marking the first time she would be publicly acknowledged as the mother-in-law of a sitting judge. Her attendance represented a significant shift in our relationship dynamics, from her previous assumption that I was unemployed, to her newfound pride in my professional achievement. She arrived at the reception wearing an elegant black dress and her best jewelry, clearly understanding the importance of the occasion and her role in representing our family within Austin's legal community. Her nervousness was visible, but she was determined to make a positive impression on my professional colleagues. "Judge Harper," called William Foster as we entered the reception hall, "I'd like you to meet my wife Margaret. She's been looking forward to this introduction." Margaret Foster approached with a warm smile that suggested she'd moved beyond any awkwardness about the birthday party situation. "Judge Harper, it's such a pleasure to meet you professionally. Patricia has told me wonderful things about your judicial service." The conversation was gracious and diplomatic, with Margaret Foster demonstrating the social skills that had made her a valued member of Austin's upper-middle-class community. Her willingness to engage positively with me despite the recent social complications showed the resilience of established social networks when managed with appropriate grace. Patricia beamed with pride as several attorneys and judges approached to express their professional respect for my judicial service and their appreciation for my contributions to Austin's family court system. The recognition was gratifying, but more importantly, it provided Patricia with the social validation she'd needed to fully understand and appreciate my professional achievement. Natalie, she said quietly during a brief moment when we were alone, I want you to know how proud I am of what you've accomplished. I'm sorry it took me so long to understand the significance of your career. The apology was sincere and represented genuine growth in Patricia's understanding of my professional life and her role as a supportive family member. Our relationship would never be without complications, but the foundation for mutual respect had finally been established. As the reception continued, I found myself reflecting on the events of the past 2 weeks and the unexpected ways that personal and professional lives could intersect in small communities like Austin's legal and social circle. Patricia's birthday party had created temporary social complications, but it had ultimately led to better family communication and clearer understanding of everyone's roles and responsibilities. Benjamin Cole approached near the end of the evening, accompanied by his wife and 2 other attorneys from his firm. His demeanor was professional and respectful, suggesting that he'd successfully navigated the awkwardness of our social encounter and was prepared to maintain appropriate professional relationships going forward. Judge Harper, he said formally, I wanted to introduce you to my colleagues and express our firm's appreciation for your fair and thorough handling of the Henderson case. Your written order demonstrated exactly the kind of careful judicial reasoning that serves families well during difficult transitions. The professional compliment was generous and helped establish the respectful working relationship that would be necessary for future cases involving his client. His colleagues nodded their agreement, indicating that his positive assessment of my judicial service was shared by other members of his firm. The evening concluded with remarks from the Bar Association president, recognizing the contributions of all recently appointed judges to Austin's justice system. The acknowledgement was professionally gratifying and provided a fitting end to 2 weeks of social and professional complications that had ultimately strengthened both my family relationships and my standing within the legal community. Driving home through downtown Austin, with Patricia and David discussing the evening's conversations and the positive feedback I'd received from legal colleagues, I felt a deep sense of satisfaction about how the various challenges had been resolved. The social embarrassment of Patricia's birthday party had been transformed into an opportunity for better family communication and clearer professional recognition. The following Monday would bring new cases, new challenges, and new opportunities to serve families navigating the complex emotional and legal issues that defined family court practice. But tonight, surrounded by family members who finally understood and appreciated my professional contributions, I felt grateful for the unexpected ways that personal complications could lead to professional growth and stronger relationships. The lights of the courthouse appeared in the distance as we drove through downtown Austin, reminding me of the responsibilities and opportunities that awaited in chambers. Tomorrow would bring new families seeking justice, new attorneys presenting their clients' cases, and new opportunities to make decisions that would positively affect children's lives during their most vulnerable moments. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out.